Airport access, FBO power, and the law of who gets to serve the jet. Hello again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now let's turn to the second hot legal topic in Florida, presently facing many airport access and control over who gets to serve the airplane once it gets there. This is where many owners make a category error. They assume airport access is a real estate or customer service issue. In fact, for large turbine aircraft, airport access is often an administrative law issue, a grant assurance issue, and sometimes a competition issue. A foundational lesson comes from Palm Beach County versus FAA, decided by the 11th Circuit in 2022. The dispute arose out of Lantana Airport in Palm Beach County. The county had an ordinance restricting pure turbojet aircraft and cargo aircraft over 12,500 pounds. But the court described the county's enforcement position as effectively banning all jets from the airport. After Captain Errol Foreman landed a Cessna jet at Lantana, the county threatened fines and jail time. Foreman filed a Part 16 complaint. The FAA agreed with him, and the 11th Circuit denied the county's petition for review. The lesson is vivid and memorable. A local airport sponsor does not get to rewrite federal access principles just because a jet is unpopular. This case continues to matter because it frames the legal architecture for Florida airport disputes. If a public airport has accepted federal funding, grant assurance constraint, how the sponsor treats aeronautical users and service providers. The rhetoric may sound local, but the law is not. That takes us to a current news driven example. In late 2025, Aviation International News and Aviation Week reported that Private Sky Aviation Realty, the longtime operator of the sole FBO at Southwest Florida International Airport in Fort Myers, sued the Lee County Port Authority over the award of a competing FBO lease to Signature Aviation. According to those reports, the dispute centers on allegations that the authority changed key terms and negotiated a more favorable lease structure without proper notice. Whether those allegations are ultimately proven is for the court, but the legal significance is immediate. One of Florida's principal business aviation airports is now the site of active litigation over who may provide large aircraft ground services and on what terms. Why is that a hot topic for large turbine operators? Because the FBO is not merely a building. It is the practical gateway to fuel, hangar space, GPU service, crew support, security access, lab and water service, catering logistics, de-icing planning if required elsewhere in the mission chain, customs coordination when applicable, and maintenance escalation. When an FBO dispute erupts, turbine owners feel it in pricing, access, congestion, and service predictability. I'd like you to remember this, take this away. For a large turbine aircraft, the airport lease is often invisible until it becomes operationally decisive. Florida makes this more important because so much business aviation is concentrated at a handful of high demand airports. That concentration amplifies the value of leaseholds, development rights, and non exclusive use structures. It also means that disputes which sound like landlord tenant disagreements are, in reality, disputes about market entry and aircraft access. There's also a deeper legal misunderstanding here. Operators often speak as though the airport and the FBO are a single thing. They are not. The airport sponsor has its own public law obligations. The FBO has its own lease rights and limitations. The operator has its own federal regulatory duties, and the aircraft owner may have contract rights against still another party. Once service interruption occurs, people discover that the legal map is layered and not flat. This is where Florida statutes chapter 330 also matter. Florida regulates airports through state law, but public airport operation remains deeply intertwined with federal law, federal grant conditions, and FAA oversight. That overlap is why Florida airport disputes can quickly become hybrid controversies involving local rules, state procurement of bidding claims, federal grant assurances, and practical Part 91 and 135 consequences. A current side example shows how public law and operational reality can collide. In April 2026, a Palm Beach County pilot filed suit challenging the state law renaming Palm Beach International Airport, arguing that asynchronous charting, database, and communication changes could create confusion and cost. I'm not suggesting that lawsuit will define aviation law in Florida. I'm saying it demonstrates the present environment. Even an airport can become a legal aviation dispute where operational systems and public authority intersect. There's a practical lesson or something to consider from this. On a large turbine aircraft, do not treat airport access as solved merely because you have a destination and an FBO reservation. Ask a more sophisticated set of questions. Is the airport sponsor in active controversy? Are there lease disputes affecting service continuity? Are there local restrictions or noise procedures that interact with federal rights? Is the preferred airport politically or operationally fragile? Is there a realistic alternative that preserves passenger expectations without placing the crew into a compressed legal or logistical corner? In short, the second hot legal topic in Florida is control over access after arrival. Palm Beach County versus FAA shows that local hostilities towards jets can collide with federal law. The Fort Myers FBO litigation shows that service access at Florida's business aviation airports can become active courtroom territory. For turbine owners, that means airport selection is no longer only about runway length and proximity. It's also about the current governance of that airport. I'd like you to take this away and remember this. In Florida, the legal right to use the airport and the practical ability to use it smoothly are no longer the same thing. Thank you for your interest in this topic. This information is provided for informational purposes only and should not be construed as legal advice. If you have questions, and they're welcome, please direct them to admin@aviationlegalcounsel.com. We look forward to assisting you with your aviation-related legal needs and addressing your questions with precision.